photo with me in the hospital?
That is me, but that doesn't mean he's my biological son.
Okay, hold on. One more question. Is this you with our son?
Yes, I'm not gonna neglect a kid, a good father, just because his father wouldn't step up to the plate. Correct.
Welcome to court, where one missing knock at the door can reset an entire judgment. Today's case turns on service of process, the rule that you can't be dragged into court unless you're properly served. Our respondent says he was on the job by 5 a.m., yet a process server claims he was served at home at 7:02 a.m. The Attorney General's office is here. There's a default judgment already on the books. And yes, there's a bombshell. One child in the order may not be his biological son, despite the marriage creating a presumption of paternity. The judge will sift fact from noise, and one document, the time card, might decide whether this case gets a new trial. Watch for the moment the court takes judicial notice, the challenge about the time card name, and the judge's final call. Quick poll. If you were on the bench, is the 7:02 a.m. claim credible?
Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, Your Honor.
Okay, thank you. You can both lower your hands, and counsel for the Attorney General's office.
Julie Damani for the Attorney General.
And I guess, Ms. Lewis, I'll let you proceed since it's your pleading. I've read it, and I understand there's no agreement on it.
That's correct, Your Honor.
And
Your Honor, before we begin, I did have exhibits 1 and 2, which was just the same thing as attached to the motion. I didn't know if it would be okay to publish it through share screen, or I believe Ms. Damani told me that you have another way that you like for them to be published. Or
yeah, and Ms. Damani, just so you know, usually if an attorney has exhibits, the way my other offices handle it is they just ask for the link to be sent before the hearing begins, and then they just put it in for them. Because as you well know, it was very hard to set up. Like a lot of AGs are struggling with it. So I don't expect someone who's not familiar with Case Center to necessarily use it in a timely manner. I find it usually takes a long time during the hearings. So I don't know if you have access, Ms. Damani. I guess we can pause the hearing and create one of those now, if that's how y'all want to do it.
Your Honor, if I may, they're attached to the motion. I don't know if that makes any difference. It looks to me like they're the same as what's already attached.
And that's correct, Your Honor. So, I mean, if the court would, I mean, I could ask the court to take judicial notice of it.
I can do that. I take judicial notice of the affidavit and his exhibit 2. Does anyone, I take judicial.
Here's your first legal milestone. The court just takes judicial notice of the affidavit and time card details attached to the motion. Translation. The judge is acknowledging these documents are part of the court file and can be considered without a witness, laying every foundation step live. That doesn't mean the documents automatically win. It means they're in play. Strategic note. When you move to set aside a default, you need admissible proof showing lack of proper service or a good excuse for not answering. Timestamps, affidavits, and consistent employment records can be powerful. Question for you. If the exhibits are the same as the filed attachments, should the court spend time wrangling screen shares, or is judicial notice the efficient call?
Time card details that are attached.
Does form matter if the substance is solid?
To the plea. Okay.
Thank you. May I proceed, Your Honor?
You may proceed.
Okay. Mr. Correa, can you please state your full name for the court?
Francisco Correa Barriga.
And where do you currently reside?
1507 Stone Mesa Drive, Houston, Texas, 77073.
How long have you lived there?
For like a year and 6 months.
Okay. And were you living at 1507 Stone Mesa Drive on March 26, 2025?
Yes, I was.
Okay. And where do you work?
I work for Admiral Glass Company.
What are your normal work hours?
My normal work hours are from 5 in the morning to about 5 in the afternoon.
Okay. And on March 26, 2025, what time did you report to work?
I was already on the clock and at work at 5 a.m.
Okay. And you have provided documentation via your time card for that week. Is that correct?
Yes, ma'am.
And does that time card reflect you clocking in for work at 5 a.m. on March 26, 2025?
Yes, ma'am, and being out at 5 p.m.
Okay, and have you seen the documentation? Well, let me ask you this. Were you at your home? Was it possible for you to be at your home at 7:02 a.m. on March 26, 2025?
No, ma'am, I was already at work since 5 a.m.
Okay, so if a return of service states that you were served on March 26, 2025 at 7:02 a.m. At your residence, would that be accurate?
This is the heart of the dispute. Was he home at 7:02 a.m. or already at work since 5 a.m.? Service of process must be accurate. Wrong person, wrong place, wrong time can invalidate a default. Courts look for credibility, plus corroboration. The respondent's story is simple. Clocked in at 5 a.m., out at 5 p.m. If that timeline holds, personal service at home at 7:02 a.m. looks shaky. But the return of service, the process server's sworn statement, carries weight too. So who's more credible? An electronic time record plus live demonstration of the app, or a return that might be mistaken? Audience check. Do you believe mistakes happen more often in busy job site mornings or in mass service rounds? Drop your take. This is exactly where defaults live or die.
No, ma'am, I was already at work.
Okay, have you ever personally been served with any court documents in this case?
No, ma'am, I have not.
Were you served with any documents on March 26, 2025?
No, ma'am.
Have you ever seen a citation or petition for this lawsuit prior to June 16, 2025?
No, ma'am. That is the
Okay,
day that I saw it on my emails.
Okay, and how many people live at your residence at 1507 Stone Mesa?
There's various family members, male and female, living there.
Okay, and are you aware of anyone at that residence may have mistakenly been served and presented any documents to you of this lawsuit?
Not that I am aware of. No, ma'am.
Okay, how did you first learn that a default judgment had been entered against you in this case?
I was going through my emails and I just happened to see that I had an email from the courts, and that's when I clicked on it and saw the information that was sent to me.
Okay, and when you received that order via email, what did you do thereafter?
I immediately started looking for a lawyer to represent and see what action I needed to take to get this resolved.
Okay, did you ever ignore any legal documents or intentionally fail to respond to this lawsuit?
No, ma'am.
And is it your position, had you have been properly served with citation in this petition, what would you have done?
The same thing that I did whenever I found out was immediately seek legal advice and get this resolved accordingly.
Okay, were you trying to avoid participating in this case?
No, not at all.
Okay, now let me ask you, you've seen the default order that was signed in this case, correct?
Yes, ma'am.
And are of the children named in the default order, are you the biological father of all of those children?
No, ma'am. There's one of the children that I am not the biological father to.
And which child is that?
Aiden Jeremiah, Korea.
Now, at the time that this child was born, you and the mother were married, correct?
Yes, we were married.
And you're still married, is that right?
Yes, ma'am.
Okay, and so though you are the presumed father of this child, is it your testimony that you are not the biological father of this child?
Notice his immediate reaction. As soon as he found the email and learned about the default, he hired counsel and moved to fix it. Judges care about diligence. If you truly weren't served, the moment you learn of the case, you must act fast. No delay, no ghosting. Also key, he testifies he would have answered had he been properly served. That goes to good cause, a staple factor when asking to set aside a default. Practical tip: always monitor mail and email, especially if you share an address with various family members. Misdelivery or confusion at a crowded residence can derail your rights. Question for you all: is an email discovery months later still prompt, or do you expect a party to sniff out court issues sooner?
Yes, and both me and Ms. Norma are aware of
I'm
it.
sorry, I don't mean to interrupt you, but Ms.
Okay.
Perez is making noises. Also, even though you are at home or you're outside, you are in court. So please treat it like court. Please try to get to a stationary location where you can focus on court and not be moving around and not having side conversations during court.
Yes, I am.
We all didn't reach an agreement, so it's real important that everyone hear what's being said. Obviously, you all care enough that you wanted a hearing, so you have to participate in the hearing fully. I require that. And then also, we generally take testimony in court. So if you are not the person being asked questions, please don't interrupt or answer or roll your eyes. Wait till it's your turn to be asked questions. If you don't have counsel, you will be given a chance to speak as well. And then, isn't that relevant for this? But I'm not with the Attorney General's office, so anything you've discussed with them or given to them beyond what's been done in court, I have no knowledge of, and I'm not supposed to have knowledge of. So just be aware of that as well. And you may continue, Ms. Lewis. And Ms. Freer, you're in a stationary spot now. You are focused and not having a side conversation. Okay, perfect. Let's proceed, Ms. Lewis.
Now the emotional fuse. He says one child is not his biological son, though the couple was married at birth. In many jurisdictions, a husband is the presumed father when a child is born during the marriage. Strong legal status, sometimes stronger than biology, until formally rebutted through proper proceedings. But today's hearing isn't to decide paternity or child support policy. It's about whether the default stands. Still, the claim matters. If the default locked him into obligations for a child he's not biologically tied to, the stakes balloon. Note the judge wisely narrows scope later, keeping focus on the new trial issue. For viewers, should courts prioritize finality, keep defaults, or accuracy, open the case, when paternity questions lurk? Where do equity and best interests of the child fit when service may have been flawed?
Thank you, Your Honor. Do you believe that it's appropriate for you to be ordered to pay child support for this child?
No, I'm not the biological father, no.
Okay, and what would you request the court to do regarding this child if this judgment is set aside?
I just get removed from the child support. That what's fair.
Okay, and if the court does set aside this default judgment, what do you plan to do as it relates to the marriage?
We would want to file for divorce and do everything the correct way and get what's needed for the children done and do whatever we need to do to make everything right and get the proper documentation and everything done.
Okay, and would you have claims or requests that you would like to make regarding your property and children and marriage if you had the opportunity to present it?
Yes.
Okay, and no further questions for this witness, Your Honor.
Ms. Damani, do you have any questions for Mr. Correa?
Just one question.
Okay.
Mr. Correa, looking at the time card details attached to the motion to set aside default judgment, it does not have your name on it.
Okay.
Where did you obtain a copy of that time card detail?
We have an app on the phone where we clock in and out, and you have to click by name to show you the correct details.
And so how can the court be sure that that was your time card?
I'm not sure if I can log into it and you see me click my name and it shows the time card. I'm gonna see if I can pull it up right now if there's a different way of showing the name or anything. Give me 1 second. Yes, my name should be at the very top of the time card.
So are you doing this on your computer or on the device, the same device that you're using Zoom on?
No, I'm using another device.
Okay.
So I don't know if I can't screen share it, but I can send it to my attorney and then she can send it to you guys. But it does have my name at the very top. It says Correa Francisco Barriga.
If the court would allow it.
I will allow that.
I just have to click back to the date. Give me 1 second.
If you're able to do it on this device, you could screen share what you're doing.
No, I have it on my work phone. Is the one that has the phone application. Okay. Oh, I don't know if I could see it on the screen here. It's Francisco Correa, and then you go to details, and then it shows all the. all the dates and times.
Are you able to go a little closer to the camera? I'm not able to see it.
I'm going to go back to the page where it shows my name, which will be here at the very top.
Oh.
Sorry.
Ms. Damani, were you able to see that?
I'm still not able to see it. I don't know if Judge is able to see it.
Yeah, you're probably looking at the earnings summary. If you look at the blue section on top, it says his name.
Yes, and then I just go to the details
That
for
no,
that
Ms. Damani?
for the week, and then it shows everything.
Yes, thank you. I have no further questions, Judge.
Watch the judge recalibrate the room. No side talk, no rolling eyes, and stick to relevant questions. This is classic judicial management, especially online hearings where distractions multiply. The objection on relevance is sustained because the court is not deciding who raised whom or marital dynamics today. It's deciding whether to grant a new trial due to service issues. That keeps the record clean and focused. Strategy insight. Litigants often try to front-load sympathetic facts, but judges compartmentalize by issue. Question to the chat. Do you prefer a judge who strictly fences off irrelevant drama or one who lets everything in and sorts it later? Which approach inspires more confidence that the ruling rests on law rather than emotion?
Ms. Correa, do you have any questions you would want Mr. Correa to answer?
Yes. So I thought this was court was about him not getting served, right? But they're bringing up about my son, and I just wanted
Ma'am,
to
your
show.
questions aren't for me. Your questions are to Mr. Correa. Is this a question for Mr. Correa to answer?
So yes. So
Okay.
my question is this him in the photo with me in the hospital?
That is me, but that doesn't mean he's my biological son.
Okay, hold on. One more question. Is this you with our son?
Yes, I'm not going to neglect a kid, a good father, just because his father wouldn't step up to the plate, correct?
So you did raise him since he
Yes.
was a baby, correct?
Correct, but he's not my biological son, and you know this.
And did you or did you not tell me that it was going to be your way, that he had no dad, you were the dad, we were married, and this was
Objection,
your
Your
son?
Honor.
Objection as to
relevance?
relevant. Oh, sorry, relevance.
I'm going to sustain the objection. All I'm addressing today is whether or not I'm going to grant the new trial. So those issues will definitely be at some point addressed, assuming they pursue their claim. But I'm not ruling on that issue today. Do you have any questions regarding the new trial?
Nope, that's it.
Okay. Ms. Lewis, do you have any other witnesses you'd like to call?
No other witnesses, Your Honor.
Okay. Ms. Damani, do you have any witnesses you'd like to call?
No witnesses, Your Honor.
Ms. Correa, you do not have an attorney representing you. So if there's anything you'd like to say regarding the new trial, now's your chance to let me know any concerns you might have about it.
Only for the case that he says he did not get served, correct?
Yes.
Okay. I mean, no, I have no other questions. He makes up his own time card, so that's the only thing I have to say.
Well, in light,
It's an app that you have to clock in on site.
sir, right now, no one has asked you any questions.
Apologize.
Does everybody rest? Does anybody anything further they wish to present?
I raise, Your Honor.
Ms. Damani?
Nothing further, Your Honor.
Okay. Ms. Correa?
Nothing further.
I'm going to
Strong move by the AG attorney. Attack, authentication. If the time card page lacks his name, how do we know it's his? The respondent counters by live navigating the app on a second device, pointing to his name at the top and the detailed punches. That's not a full evidentiary foundation, but it's smart persuasion. Show the system, not just the screenshot. Courts like records that can be traced to a regularly conducted business activity with identifiable authorship. If the judge trusts that the underlying record can be properly authenticated later, it supports granting a new trial so evidence can be vetted in full. Question: does a live demo of a work time app make you more confident in the data, Or do you still want a custodian affidavit at trial?
Grant the new trial. And I'm going to reset the case to be heard. For anyone to file, consult lawyer. You may want to consult a lawyer, Ms. Correa, to file any necessary pleadings. If they do file a divorce, there's a good chance this will get consolidated with it and not be before me, but who knows? We'll reset it just in case, and then we'll see what's happening by the time that setting comes. July. What date would you like to use, Ms. Damani?
Judge, either September 30th or October 17th.
Will September 30th be enough time for everyone to prepare?
Yes, Judge.
No, not for me.
How much time do you need, ma'am?
I would like until October.
Judge, I would just like to let the court know that I am prep set in Harris County for a 3-day trial on the 16th, 17th, and 18th, I believe, of October.
The 18th is a Saturday? Do you want to?
Okay, so then maybe it's Wednesday, Thursday, and Friday. Let me
so
see.
It's the 15th, 16th, and 17th. Okay.
Okay.
If we don't do that, we would be moved out to October 28th.
Okay.
That would work, Judge.
So the AG's office, well, Ms. Damani, are you going to prepare the order?
Ms. Lewis, did you have an order?
I believe so. If I didn't file it, I can get it filed this morning. I apologize about that.
If you can send it to me, and then I can get it to Judge for signature.
Sure, will do.
Thank you.
Okay. Okay, then everyone is free to go, and we'll see what's happening on October 28th.
Thank you,
Thank you.
Judge.
Thank you.
There it is. New trial granted. The judge resets the case and signals a likely consolidation if a divorce is filed. Smart, because paternity, support, and marital issues often interlock. Practically, this wipes the default judgment off the board and reopens the file so service, paternity presumptions, and financial obligations can be addressed on the merits. Takeaways. 1. Service of process is the gateway to justice. Get it wrong, and even solid claims can unravel. 2. Diligence matters. The faster you act after learning of a default, the better your odds. 3. Presumption versus biology will need formal resolution if pursued, with serious consequences for support and parental rights. Hearing now set for October 28th. Watch for motions on paternity testing, proper authentication of work records, and potential consolidation. If you found this case as shocking as we did, make sure to hit like, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.